I want to welcome everybody back to the FITSNews studio. We've got a very special guest today, one who is bound to make a ton of news, I believe, hope so. But we are welcoming to the studio today David Pascoe, who is the First Circuit Solicitor. For those of you who don't know, that's just below Columbia, up the road from Charleston, sort of in the middle, kind of a rural part of the state. Includes Dorchester, Orangeburg, Calhoun, one other county. I'm missing one.
That's it, Dorchester, Calhoun, and Orangeburg.
I got all three. How about that?
Did great.
You were elected in 2004. You knocked off a Republican incumbent. Is that right?
Yeah, 12 years of incumbency. Well, actually, and Solicitor Robbie Robbins, who I defeated, good friend of mine, he was solicitor at the time. He had been appointed solicitor in 2004.
Okay.
So he wasn't an elected solicitor.
Oh, okay. And so, but you won the November election.
The November election against Solicitor Robbins. He was running for Mandy's seat down in Somerville.
Okay.
And I've been solicitor since January 2005.
Won re-election, what, 4 times? Is that 4 times?
I believe so.
Wow.
Whatever, 04, 8, 12, 16, 20.
20, yeah. Now, before we get into the meat of this, I'm going to put you on the spot with a political question.
Sure.
That's a pretty good electoral record. Are you going to go for a higher office in 2022?
No.
No.
I've been incredibly flattered. I've been approached by political elected officials from both parties, Republican and Democrat, asking me to run for Attorney General and other offices. Of course, as you know, I've been approached by political party activists to run for both parties, but I have no intentions right now, none, zero, to run for statewide office. And the fact that I'm here, and the fact that I've talked to the Greenville GOP, the Newberry GOP recently, Democratic parties are inviting me now, Rotaries, kind of proves that I don't want to run for statewide office, because if you want to run for statewide office, you have to make friends. And I'm not out on a make friend tour, as you know.
That's never been your problem, is it?
No, I believe, I'm not worried about popularity right now. I'm worried about the truth and what's right. And if you're going to run for statewide office, you got to worry about popularity.
That's true. Well, let me ask you this. Obviously, some political calculation there. 2022 is not going to be a good year for Democrats. So if you were to run on the statewide ticket as a Democrat in 2022, that's a death sentence, right?
Honestly, I think it's going to be very difficult for any Democrat to run in South Carolina in 2022. It's been difficult in 2020, 2018, 2016. You can go all the way back to the early 90s. The last time we had a Democratic Attorney General was what, 1990, with the election of Travis Medlock?
Been a while.
So it's been a while, yeah.
And we'll talk about the current occupant of that office here in a moment. But before we get into that, I wanted to take you back. You were obviously a very effective prosecutor down in the First Circuit, but not a lot of folks at the statewide level. I mean, obviously there's some big cases you had. The case involving I think you convicted the only murder case without a body. In
Richland County as an assistant prosecutor. I did that, Jeffrey Weston, and some other real high-profile cases when I was an assistant prosecutor in Richland County.
Yeah, quite a feat. On the statewide level, though, you became a household name 2016, 2017, 2018 as this Probegate investigation sort of burst onto the stage. It was an anti-corruption investigation. You led that investigation, and we called it Probegate because there were some disputes over who should be leading that inquiry. You ultimately prevailed before the Supreme Court. Were granted with the authority to lead it. Tell us a little bit about that investigation.
All right, that's a great question. And one of the things I'm trying to do is educate people about how the Probegate started. Back in 2014, Bobby Harrell, his lawyers had made a motion to recuse the Attorney General's office for whatever reasons. And there was a good chance it was going to be granted. So Attorney General Alan Wilson asked me if I would handle the Bobby Harrell investigation.
And tell viewers who Bobby Harrell is.
Well, Bobby Harrell, of course, he was the Speaker of the House for the state of South Carolina, back from 2006 maybe to 2014.
Very powerful.
Well, he was the most powerful person in the House. When we tried the Jim Harrison case, and remember Jim Harrison was chairman of the Judiciary, testimony came out that the two most powerful people in the House of Representatives were Bobby Harrell, number one, and Jim Harrison, number two. So he asked me back in July of 2014 if I would handle the Bobby Harrell investigation. I looked at it, and I agreed to do it. In that report, the SLED report, which was given to the Attorney General's office in December of 2013, it outlined potential crimes by Bobby Harrell, but also potential crimes by Representatives Rick Quinn and Jimmy Merrill when they were majority leaders in the GOP caucus. What happened was I indicted Bobby Harrell, I think it was in September of 2014. The SLED agents on the case continued to hammer me, solicitor, what about these other people that we mentioned in the file? Why isn't anybody looking at them? The Attorney General's office isn't looking at Merrill and Quinn and the other allegations we have in the report. And they're pretty fired up about it. I said, well, guys, that's not my problem. I'm doing Bobby Harrell, but I'll tell you what I'll do. I'll send the Attorney General an email asking him to look into it and telling him that we think, SLED and I, that there are problems here, potential crimes. And I did that, I believe it was on October the 1st, 2014. Or October the 1st, 2014, I'm sorry. Well, we convict Bobby Harrell in October. Later in the month, and this is in the grand jury report, which one of the reasons I'm going on this speaking tour is asking people to read the grand jury report, which you can find on my website. But the Attorney General went to Richard Quinn for advice on how to get me off of the probe, which he really didn't even need to do that. Because the very next day, he and I had a cordial conversation. I agreed with him that no, I was only brought on to handle Bobby Harrell, not Rick Quinn and Jim Merrill.
And Richard Quinn, of course, is the father of Rick Quinn, the majority leader you mentioned, one of the more powerful Republican political consultants who advised a lot of these leaders that you were targeting.
And paid a lot of these leaders.
Right.
Remember, he paid Jim Harrison, he paid Rick Quinn, he paid Jimmy Merrill and others. So I'm off the case, happiest man in the world around October the 24th. Didn't have anything to do with it. October, November, December, January, February, March, April, May, June, July. Finally, 10 months later, SLED continued to just incessantly, what about these two? What about Merrill and Quinn? What about Merrill and Quinn? Well, finally, the Deputy Attorney General at the AG's office relented, and really per Chief Keel's request, because he wanted me on from the beginning with Bobby Harrell. I got a letter out of nowhere, not even a phone call. Here, the file's yours. Take it. And that was in...
Authorizing you to investigate the other names.
The other names. July 24th, 2015 is when I received the letter. I can go further and tell you how the probe really got going again. I had the case, sat on it, because I have thousands of other cases to deal with. But every now and then I would meet with SLED, we would discuss it. And in the fall of 2015, I asked the Attorney General's office for an opinion as to whether they thought it was a crime what Merrill and Quinn was doing, which was they were sending hundreds of thousands of dollars to their businesses because of their position in the GOP caucus. They used their position as majority leader to secretly direct hundreds of thousands of dollars to their businesses. I mean, to me in SLED, it was a no-brainer.
Sure.
It's a crime. It needs to be looked into. And we were learning about other things that needed to be looked into. I wanted the opinion, as I told SLED back then and my friends and the other prosecutors on, I wanted to get the AG's office out and see what the defense is going to be if and when we indict these people. I expected a 4 or 6 page opinion at most, because it's an easy issue. Is it unlawful for a person to use their position in government to make money?
Right.
The answer is yes.
Yeah.
According to a 46-page opinion by the Attorney General's office, the answer was no. And we couldn't believe, well, actually we could believe it. I knew it was going to be no, but I didn't think it would be a 46-page opinion. It took me 6 days to read it. Well, Chief Keel and I disagreed with the opinion. Our own expert that we hired, Herb Hayden, the former executive director at the Ethics Commission, he disagreed with it. And we moved forward with our investigation. In March of 2016, Chief Keel and I decided it needed to go to the grand jury, that it warranted a grand jury investigation with grand jury subpoenas, witnesses testifying, and we got Judge Newman, Clifton Newman, to agree with us to impanel a grand jury, and then the rest is history. The AG's office took me off the case. I took it to the Supreme Court. We were fortunate enough, I guess fortunate, I don't know if that's really a good word. People would call and congratulate me and say, well, congratulate me for what? I would have been much more happy if the court had said, it's not your case. But in the summer of 2016, that's when the probe started. The court said, yeah, Pasco, you can go start your investigation with SLED.
So there was a battle before before your grand jury for the Quinn defendants. You had to fight the battle just to get to the point of being able to proceed with the investigation into those two. When you did move forward with that investigation, walk us through a little bit about, obviously, multiple leaders in both chambers went down in connection with that. Let's talk a little bit about, first, the success of that investigation, because obviously you did bring it home when it came to identifying, exposing, and then holding, to some degree, these Republican leaders accountable. Walk us through some of those indictments and the people who went down and the consequences they ended up facing.
Yeah, and let me try to think if I can put it in order. And I'm going to be a little careful.
Sure.
Because remember, there's still pending cases that my good friend Solicitor Barry Barnett is dealing with the probe. But I can talk about the convictions, obviously.
7 years later, still pending cases.
Still pending cases, yeah. And think about the delays that we ran into, whether it was taint team, whether it was the AG starting the delay for over 10 months, the taint team delays, the courts. So yeah, still going. But I can promise everybody this: it's in great hands. You can't have a better solicitor handling it than Barry Barnett. That's David Pascoe included. Barry's as good as they come.
Strong recommendation.
He's as good as they come. So we looked at Marilyn Quinn. We got records, obviously, bank records, and we did a search at Richard Quinn and Associates and got more records. What we learned is that those legislators, specifically Merrill, Rick Quinn, Jim Harrison, made $900,000 in a little over a decade for doing absolutely nothing at RQ&A, other than voting and sponsoring legislation for lobbyist principles, whether it was like a Blue Cross Blue Shield, Palmetto Health, SCANA. Other than doing that, he did absolutely nothing for RQ&A for that money.
While those entities were paying
RQ&A. And that's a great point. What happened is the lobbyist principals pay the consultant, RQ&A, and then this consultant is paying all these legislators money. And again, Harrison was making over $80,000 a year. He didn't even go to the office. That was testimony at trial. But he would go and vote on legislation for SCANA and some of those other companies. So we first indicted Jim Merrill with the county grand jury, not the state, for misconduct in office. Again, using his position to make money. And to me, the clincher was, on all of them, they were failing to file that they were being paid by lobbyist principals. And I thought that was the slam dunk on every legislator that we could go forward on.
They just didn't report it.
They didn't report it on their SCI. So he was the first person, I believe he was the first to get convicted. Affable, I've met with him a couple times, likable person.
Yeah, nice guy.
Smart guy too, and but he didn't do things the right way. Then maybe you'll have to refresh my memory. I know we ended up indicting Rick Quinn. Another real big surprise to us was John Corson.
He was the Senate president at the time.
So President Pro Tem, arguably the most powerful person in the Senate, or at least title-wise. And I'll never forget it. The SLED agent and one of my lawyers coming to me saying, why, can you think of any reason why the political consulting company, Richard Quinn Associates, is paying money to John Corson? And at that time, we had like 2 or 3 checks, all under $10,000. I said, I have no idea. But I tell you what, I want you to go in there, and I asked them to do this for me. They stayed up all night and did it. Find every single check. Find out, whether there's more, and give me some type of, a timeline and a graph of all the checks. Next morning, I go into work, and there's this graph on my desk. And I went into their offices. I called them in there and said, y'all obviously prepared this graph. Do you see what I see? And one of my lawyers was like, yeah, it's just really weird. He's gotten, was either 12 or 13 payments. I said, this is structuring.
Yeah. This
is money laundering. John Corson's campaign account writes a check signed by him to Richard Quinn and Associates for quote-unquote services. And then many times it was on the exact same day, he's getting a check back for less than $10,000 from RQ&A, and he's cashing it at the bank. I said, this is structuring. And I'm not going to go into...
It's another pass-through.
Another pass-through. But and I'm not going to get into the major details now. Maybe eventually I will. I begged the feds.
Yeah.
It was slam dunk money laundering and structuring. And I really thought, for those that think, oh, Pasco wanted to keep this case, I said this. I went and met with the feds.
And you thought they should have investigated Corson and Richard Quinn?
All of it.
Okay.
I said once you had that one angle, dealing with money laundering over $100,000, structuring of money, involvement of banks, take it all.
Yeah.
And I was optimistic. I thought they were for a while. And then, for whatever reason, they decided not to.
What was the reason?
I've got my suspicions, but I'm just going to keep it to myself for now.
Teasing us, man.
Well, maybe next time I'll come on the show. But there was no, in my opinion, there was no reason not to take it.
Sure. I want to ask you about this. You, in laying out some of the charges against the ringleader of this operation, Richard Quinn, who, again, still facing some perjury charges in connection with this inquiry, but you said that he used legislators, groomed legislators, and conspired with legislators to violate multiple state ethics acts, all so he could make money. That's the pay-to-play scam.
I think I probably said that at a bond setting.
I believe you did.
Or his guilty plea, one or the other, yeah.
And the grand jury that was impaneled for you to present information and evidence, they agreed with you. And they issued a report in October 2018. And I want to bring this up because I do think we have to talk about the other side of the pie. We've talked about all the elected officials that you did indict. They all resigned from office. One of them actually refused to plea and went to trial, and you convicted him.
Went to prison.
And he went to prison. So obviously those are not good results, but from the standpoint of holding people accountable, it's good for the public trust. It's good for the public to see that crime didn't pay completely for those guys. But I want to bring you to this part about those were the puppets, so to speak. But now I want to bring you to the part about the puppet masters now. And this was from the grand jury that, again, you were presenting evidence and which indicted on your recommendation. And they're talking about the corporate entities now.
Okay.
They said that these entities retained Richard Quinn for the purpose of gaining access to and influence over public officials. And that by failing to report Quinn's services, they influence the outcome of legislative matters with no accountability or disclosure to the public, which is a crime, right? Okay, so here's the question. Why didn't the puppet masters get charged?
The lobbyist principles?
Correct. Why didn't the special interests that were buying these politicians?
Question. No, I'm glad you asked it. That's a fantastic question.
Because they broke the law, didn't they?
According to the grand jury, and I'm so glad you brought up the grand jury report, because that is the report of the 28th state grand jury. It is not Pasco's report. People say, oh, it's David Pascoe's report. No, it's not. It is the grand jury's report. And according to the grand jury, Will, you're absolutely right. There was probable cause, not proof beyond a reasonable doubt, but probable cause that these lobbyist principals, and I've got my little cheat sheet to remind me who they were, the trial lawyers, AT&T, SCANA, Palmetto Health, and the University of South Carolina. Probable cause.
Pretty influential groups.
Yes.
In South Carolina politics.
Yeah, you think? No, you're right. And in the courtrooms too, trial lawyers. There's probable cause that they committed, quote, illegal lobbying. Okay?
Which means you should have indicted them.
Which means, I'm going to tell you, I had three options.
Okay.
Great question. Three options. And then maybe I'll ask you which option would you have taken.
Fair enough.
The first option was to do nothing. Because probable cause is not proof beyond a reasonable doubt. We were going to have all kinds of criminal intent issues because we couldn't prove that the legislators knew, or it would have been difficult to prove, I should say, difficult, not impossible, that they knew that Richard Quinn and Associates was paying legislators. Every one of those companies denied knowing that Richard Quinn and Associates was paying legislators. In fact, they testified, many of them in the Harrison trial, remember, and they would say, oh, if we had known he was paying legislators, we never would have put RQ.
They were shocked to discover that gambling was going on in the establishment. Right?
There you go. Yeah. So again, not saying it would have been impossible. So I could have done nothing.
Okay.
And that's just never an option for me, as proven back, when I got the AG's opinion in 2015, and they said what Quinn and Merrill are doing aren't crimes, I could have done nothing. I could have said, oh, see, may I call it? No problems here, and walked away. For whatever reason, I have a habit of grabbing the elephant by the hind legs. So doing nothing was not an option for me.
Okay.
with these lobbyist principals. My second option was I could enter agreements with them. All right, these were often referred to as corporate integrity agreements. And I decided to do that because for the first time ever, companies were held liable and they were subject to prosecutorial scrutiny in their dealings with the legislature.
Okay.
The agreements provided remedial and punitive measures, and I want you to remember this total, in the amount of $352,000. All that money went to the state of South Carolina, by the way. And when we get back to why that's important. Eventually, when I got permission to send it from a judge, I wanted to wait and do it the right way and get a judge to do it. And that's, I want you to remember the figure of $352,000.
Okay.
So, and also the agreements put every lobbyist principal and all these corporate entities on notice that at least from 2018 to 2021, when I was on the case, you guys are being watched. You do this again, you're going to be prosecuted. Now, why enter the agreements instead of prosecute the cases? Well, we had a bunch of major issues in trying to get these cases to court. One I just talked to you about, the criminal intent. But the two most important reasons, or the biggest obstacles, were number one, the statute of limitations. Believe it or not, illegal lobbying is, other than bad checks, I think, the only crime that I know of that has a statute of limitations. It's only 4 years. So we would have had to try to get over that hurdle of the statute of limitations issue as discussed by the grand jury in their report. We had those issues because of delays caused by the Attorney General's office and the courts. Secondly, even if I could have gotten over the hurdle and convinced a court, hey, take my argument on the statute of limitations issue. We can still prosecute these cases even though it happened more than 4 years ago. Even if I had done that, and even if we spent the hundreds of thousands of dollars to try each one of those cases individually, and even if we convicted them, and even if our state Supreme Court had upheld and affirmed the convictions, even though we know now after Harrison they would not have, if I had done all of that, the penalty for these companies is an absolute joke. It's a fine of $2,500 and a timeout from lobbying. Nobody's going to go to jail. They're not going to pay between $60,000 and $100,000 to the state of South Carolina like they would have had to, like they did under the agreements. They would have paid a $2,500 fine and walked away.
Even if you had convicted them.
If I had convicted them. So it was really a no-brainer. And I can tell you this, I went to the companies with what we did was, and this is part of the report, we got disclosure orders from Judge Newman to show them the grand jury report. And they had to decide whether I was bluffing. And I can promise you now, there's no reason for me to lie now, I wasn't bluffing. Had they not entered the agreements, I probably would have indicted them or sought indictments from the grand jury.
Now you mentioned, though, the Supreme Court and, I guess, a lack of support from the Supreme Court as it related to upholding the convictions. But I did want to refer you to a quote from one of the justices who was quite critical of the corporate integrity agreements, Justice Few, who said, and I quote, "Pasco accepted hundreds of thousands of dollars from major South Carolina corporations on the promise not to prosecute them for conduct the state grand jury found probable cause to believe is criminal." How do you respond to that other than...
A couple of things I'd like to say. If he had read the report, the grand jury knew exactly what we were going to do. They were part of this, okay? And then more importantly, this is what I don't understand. He said that in an opinion, and I think he also referred to, he's going to ask Pasco these tough questions in the Harrison appeal, right? So
You came before him.
I came before him again months later on the Jim Harrison appeal, armed and loaded and ready to go to explain the corporate integrity agreements, why we entered them, because he sent that notice. He said some other things. Hey, we're going to ask these questions.
He did.
And do you know how many questions Justice Few gave me about the corporate integrity agreements? 0. None. In fact, I appreciate it. He actually commended me for the grand jury probe and what we discovered. And I was very disappointed because I got no questions on the corporate integrity agreements after he said that. And I almost got no questions from the rest of the court. They were all easy questions, the ones I did get. None. 0.
But still, you can acknowledge the perception, though, because, again, the money that you reference, it did eventually flow to the state, but initially that $350,000 went to your office.
No, it went into an escrow account.
Which was managed by your office.
Which was managed by my office to never be touched, period. And it was money set aside by itself until, and I told the Supreme Court this, until I was going to go in front of a trial judge to have that judge determine where it should be dispersed. Now, I wanted it to go, all of it, to the South Carolina Ethics Commission because they're underfunded, and my argument was they're the group that has to monitor these lobbyist principles. But the judge decided that it needed to go to the general fund, and every penny went to the general fund. That money was never touched, never.
Let's ask the bigger question, though. Moving past the particulars of this investigation, in the future, how do you hold these corporate entities responsible? Because, again, it's one thing to take down, the politicians who are benefiting, but if we don't take down the people paying them, we're just going to get a new set of politicians getting paid by the same interest. So how do we address the root problem here?
Like the grand jury said, the first thing we need to do is we've got to get rid of the 4-year statute of limitations.
Okay.
I mean, usually you're not even going to know that there's been illegal lobbying until after 4 years. Second, we have got to stiffen the penalties in our ethics laws. Illegal lobbying, a misdemeanor and a $2,500 fine. No, it needs to be a felony. If we run into this situation again, it needs to be a 5-year felony. CEOs need to be on notice that you're looking at prison time. The fine needs to be a lot more than $2,500. It needs to be, 5, 10, 20, 50, a lot more than $2,500. So get rid of the statute of limitations. Provide a much harsher sentence and give the Ethics Commission positions where they can monitor these lobbyist principles and their activities with political consultants in the legislature.
I want to shift focus in our conversation now. We've talked a lot about the public corruption investigation at the State House, which you led, resulted in a number of positive outcomes. Some, including myself, have argued it left a little meat on the bone, but I appreciate you addressing those questions and taking the time on that subject. But I want to shift us now into the issue of judges, into the issue of judicial conduct, into the realm of judicial accountability. Because as we look at the Murdaugh murder saga, it's very clear that there are questions about judicial integrity in the 14th Circuit, which is where the Murdaughs essentially ran a fiefdom for over a century, really. Some of the judges down there very closely tied to the Murdaugh firm, to the Murdaughs themselves. You've had some experience with one of those judges because she was a star judge on the Probegate investigation. So I wanted you to tell us a little bit about Carmen Mullen. Your relationship with Carmen Mullen obviously got very heated during the Probegate investigation, but tell us a little bit about Judge Mullen.
And the Supreme Court still has her on the Probegate case right now with Solicitor Barnett. So therefore I'm going to stick with the old adage, if you don't have anything nice to say about someone, don't say anything at all. I don't have anything nice to say.
Okay.
And particularly Will, because, and you brought it up, she's also embroiled with some stuff going on in Hampton County in the 14th Circuit regards to the Murdaugh civil actions. And I would hope that judicial conduct, the Commission on Judicial Conduct, or someone is looking into why a judge would sign an order weeks after they've recused themselves from the Murdaugh BUI cases.
Correct.
Very importantly, whether the judge knew that the order was not going to be filed. Those things need to be looked at promptly to restore integrity in the judiciary, because the judiciary has been taking a shot.
What accountability is there in that process? So obviously there's a criminal investigation underway right now into the Murdaugh family, and particularly there's a public corruption investigation, which we, again, don't have any definitive proof, but we're assuming that judges are a part of that. But beyond the criminal investigation, obviously there's a Commission on Judicial Conduct, but have they heard any evidence on Carmen Mullen? Or
I don't know, and that's one of the things we need to change in this state. So first, yes, they need to, and I hope that they are, because this is about the integrity of the judiciary. But secondly, what you bring up is we need to have more transparency with the Commission on Judicial Conduct. I mean, there's absolutely
what is this entity? Most people haven't even heard of it.
Will Folks files a complaint against Judge Smith. It goes not to ODC. It might go to them as a pass-through, but it goes ultimately to the Committee on Judicial Conduct, which is made up of each panel. They have 4 different panels that meet during the year. This is what I'm told, because it's very secretive.
Yeah.
Too secretive. They have basically 10 judges on it.
It's judges overseeing other judges.
Judges, that'd be like, if you had a complaint against David Pasco, we'll let 10 other solicitors hear that complaint against me.
Right.
Yeah, judges overseeing other judges. And we don't even know when they meet, when those 10 judges meet to discuss a judge's conduct, we don't even get to know who the 10 judges are on that panel.
So none of their hearings, none of their proceedings are public?
None of it's public. None of that is public. And if the case is...
Are the complaints public?
No. Unless, now the good thing is the person who drafts the complaint, who says it, can make it public. But judicial conduct's not going to do that. And if they dismiss it, they send you a letter saying the complaint is dismissed, no explanation needed. They don't even give you an explanation. So we got to, you've been beating this drum
Sure.
for a while now, and I'm starting to beat it. We've got to find better ways to pick our judges in South Carolina.
What is a better way?
Well, how Winston Churchill said that democracy is the worst form of government except for all others. The way South Carolina picks judges is the worst way of picking judges compared to all others, period. I don't know what the solution is other than do something different we're doing now. I was never a proponent for popularly elected judges. When I talk to district attorneys in California and other states where it takes place, it is much better than what we have in South Carolina. And it could be something as simple as go ahead and let the legislature vote on the judges to continue, even though we're only 1 or 2 states that does that.
Right. Virginia, the other.
And Virginia doesn't, to my knowledge, they don't elect all their judges like we do, just some of them. But it could be something as simple as just scrap the JMSC, Judicial Merit Selection Committee, or change the membership. Take the legislators off of JMSC and let private citizens sit on it. Members of the bar. And they can decide who's qualified. And don't do this 3-person limit. If 10 people want to run for judge in the First Circuit and they're qualified, make the legislature vote on all 10 to decide which one comes out. Might be as simple as that, but we got to get the JMSC because that's where the judges are selected. It's with JMSC. We got to get them off.
Now, you've been very critical in your presentations that you've been making up in Greenville, Newberry, some of the other places you mentioned. You've been very critical of this panel and its chairman, Murdaugh Smith, one of the more powerful Republican leaders. Are you saying Smith is corrupt? Are you saying this commission is corrupt?
I'm saying that the way we select our judges can lead to corruption with certain judges. Look, first of all, and this is the big picture problem, you have to have a completely independent judiciary. If you're going to have a separation of powers, even our founding fathers knew this, you have to have an independent judiciary. You cannot have an independent judiciary when they are selected, elected, and solely fired by another branch of government, the legislature. And look what goes on with JMSC now. You brought up the race in York County.
York County, correct.
Don't even know Judge Hall. He's probably a great guy. I don't know. I've heard both sides.
Sure.
I've heard some tell me what a wonderful person he is. Others, not so big a fan of his. But I know this. He should have had an opponent.
Well, he did have an opponent. They just wouldn't let her run.
And that's because of the JMSC. That's when I said they select our judges. When you have someone with 15 years experience as a prosecutor, she's already qualified to run for judge, period, at least on paper. But throw in the fact that she's been a master in equity, which is solely civil law, for I think 3 or 4 years.
She was eminently qualified.
On paper, she's more qualified than 80 to 90% of all people that run for judge and come out qualified. There was only one reason to keep her out. That was so Judge Hall could be unopposed.
Yeah, protect the income. Let's talk about some of the real world consequences. I know you're pressed for time, but I do want to get to sort of the heart of this issue. South Carolina is experiencing an alarming increase in violent crime. Murders are through the roof. sexual assaults on law enforcement officers. Much of this violence, or at least the prosecutors I speak with, they're telling us it's the same offenders
Every time.
over and over, but they're continuing to be let back on the streets because judges aren't setting bonds or judges aren't adhering to violations of probation. They're not ruling them in. There's also allegations that prosecutors and some of these state agencies responsible for enforcing probation just aren't doing their jobs either. What has to happen to make these violent numbers go down? Because again, it's clearly just a handful, again, of the same people reoffending.
First, my brethren and I need to all start speaking out.
All the solicitors.
All 16 of us need to start speaking out, going to the Rotaries, doing what I'm doing, going to GOP and Democratic Party events, and tell people, and you've seen it in my slides, one of the things I hit hard on is that violent crime, especially homicides, are at its highest level since the early 90s. It's going through the roof. So we need to first start talking about it. We need to talk about bond reform. I'm glad you brought that up. Shoplifters don't need to stay in jail for 3 months because they're poor. We got to stop that. But at the same time, on the other end of the spectrum, we got to stop letting these repeat offenders out of jail. You know, we get people that are locked up on drug trafficking. A month later, they get picked up on a gun. They're back out on bond because of the magistrate's bond. A month later, picked up on drug trafficking again, out on bond. And we can't, and we're having a difficult time getting their bonds revoked. They need to stay in jail. So bond reform's big. We need a docketing bill in the state because the docket is going through the roof. It's been a horrible 4 or 5 years dealing with the docket. We had a docketing bill that I thought for sure was going to pass in 2018. It was supported by the solicitors, the trial lawyers, the Public Defenders Association supported the bill, and Senator Malloy filibustered it in the Senate.
Don't we need more prosecutors and more judges too, just to address the backlog, the growth in the population? Don't we need a larger system to handle the inflow?
I told somebody yesterday that in order to handle the docketing issues, the problem's complex, but the solution is simple. We need more funding for solicitors and public defenders. You can't have assistant solicitors handling on average 500 cases per assistant solicitor and have an effective job of moving those cases. So more funding for solicitors and public defenders. We need the legislature to stop abdicating its duty. It has a constitutional duty to come up with a docketing bill, a docketing law, and they haven't done it since Langford. And finally, going right back to your point, the judiciary needs to be better funded. I think they should at the very least all have more than one temporary law clerk. They should have, like in the federal system, they have 2, 3 law clerks, one that'll stay for several years to help get the cases docketed, to help work on the docket. So yes, I think we don't need more judges. I would disagree with anybody who says we need more circuit court judges. We've got plenty of judges, but they need more help. Man, those people, those judges come to court sometimes almost, for lack of a better word, naked. I mean, they have no staff. They have one law clerk right out of law school. We need to give them more than just one law clerk out of law school.
And we obviously, as you mentioned, have to find a way to hold them accountable that's beyond a bunch of lawyer legislators picking who sits on the bench and who doesn't.
Exactly. Yeah, we got to have a better way. And that's why now I'm starting to sort of be in favor of popularly elected judges. At least then.
You're not going to get in trouble talking about that.
Well, but at least then they're accountable to the people.
That's right.
And if judges are going to be, and this is and I respect Chief Justice Beatty, and I appreciate that he wants to grab the bull by the horns with the docket. They want the judges to run the docket, then they need to be responsible to somebody. And who better than the people in their circuit or the people in their county? When I ran for solicitor in 2004 and 2008, we were in charge of the docket. And that's the big campaign issues. How is that solicitor handling the docket? Well, we don't run the docket anymore.
It's been taken away from you.
By the courts, and that's fine. And it really, quite honestly, in the perfect world, that's the way it should be if there's enough funding for it. We just haven't provided enough funding. But if the judges are going to be responsible for it, then they need to be responsible. They need to be held accountable, either by the people or someone other than lawyer legislators.
Well, because right now, justice is suffering, public safety is suffering, and public faith in these institutions is suffering. But Mr. Solicitor, appreciate you taking the time. answered some tough questions. Appreciate your work. Thanks for coming on and spending some time with us today.
Thank you, Will. I really had a great time too. Bring me back anytime.
Absolutely. Appreciate y'all tuning in as well. Thanks.
Thank you.